Well, good afternoon and welcome to Understanding Paid Leave Requirements to Ensure Compliance. Thanks for joining us today. I'm Raleigh Merrill with GTM Payroll and HR. In a moment, I'll introduce to you our presenter. But first, feel free to use the questions functionality to ask your questions during today's presentation. Then we'll get to those questions, as many as possible as time permits, at the end of the presentation. You can get to the question functionality. Just look for that box with the question mark towards the upper right of your screen. Also, you'll receive an email later today with a link to watch a video recording of this presentation, as well as a PDF version of this presentation. Our presenter today is Jennifer Berry, a senior HR consultant with GTM and our assistant HR practice leader. Jennifer brings more than 20 years of human resources experience to the GTM team, including managing and advising on the HR lifecycle for many organizations, including small to mid-sized not-for-profit organizations and even larger global organizations. Jen's experience includes advising on mergers and acquisitions, HR project management, HR and benefits compliance, cybersecurity compliance, and more. She's led HR and process audits, ERISA audits, employee handbook projects, benefits administration platform development and deployment, and she's developed and delivered training on HR benefits compliance. Jennifer's also consulted with clients in all areas, including HR, leave management, talent acquisition and termination, benefits enrollment, compliance and ACA, HIPAA, COBRA, and state and federal compliance notices. So at this point, why don't we tap into this knowledge and experience, and I'll turn things right over to Jennifer Berry.
Thank you, Raleigh. So, leave management is one of the most difficult tasks that an employer and even an HR department may undertake. Balancing the various federal and state leaves is often difficult and can have tremendous fallout if done incorrectly. When managing leave and benefits related to leave, be sure to be updated on FMLA, paid family leave, disability laws, workers' compensation, and how they all interact with each other. The complexities associated with managing these types of leaves have often been described as drowning in alphabet soup. However, following this presentation, we hope that you feel better prepared for the task. In addition to educating HR teams on leave management, we recommend utilizing a leave tracking system and/or leave administration team to assist in leave management, to remain compliant and to take the burden off overtaxed small HR teams. It assists with privacy laws related to medical leaves, tracking leave that runs concurrently, confirming return to work, working directly with carriers, etc., etc., etc. So let's jump right in. The first important step as an employer is to determine if you are a covered employer under the Family Medical Leave Act, and if so, which of your employees are eligible employees. Although many employers do think that FMLA applies to them unless they have 50 or more employees, it's important to realize that certain employees must provide FMLA regardless of size. So private sector employers are the one with that 50 employee limit. So if you have 50 or more employees for at least 20 weeks of the current or preceding year, you are required to offer FMLA. Public agencies, including state, local, and federal employers, they also have to offer FMLA regardless of how many employees they have. Local education agencies, including elementary and secondary schools, both public and private, school districts, etc., no matter how many employees. Even if the employer is a covered employer, as we just discussed, you must also determine if the employee is eligible based on time worked for the employer, and that they must have worked for the covered employer for at least 12 months, plus their hours of service over those 12 months, which must be at 1,250 hours of service in the 12 months immediately preceding the leave. In addition, if you're not working at a work site that is within 75 miles of where the employer has 50 or more employees, you are not eligible. So let's talk about the different types of FMLA or why you can take FMLA leave. If you are a covered employer and your employee is eligible, if they mention the need for leave for any of these reasons, you're obligated to offer them FMLA for the birth of an employee's newborn child, the placement of a child with the employee for adoption or foster care, a serious health condition that makes the employee unable to perform the functions of his or her job, care for the employee's spouse, child, or parent who has a serious health condition, any qualifying exigency arising out of the fact that the employee's spouse, child, or parent is a military member on covered active duty or are called to cover active duty status, and care for a spouse, child, parent, or next of kin who is covered service member with a serious injury or illness. When dealing with FMLA, determining eligibility is really the beginning of some of the issues related to determining how to administer it. Oftentimes, you have to balance laws and policies. Many of these eligible reasons for FMLA leave qualify for other leaves or for other insurance benefits provided by an insurance carrier, which require the employer to track multiple leaves that are concurrent, non concurrent, or that may be intermittent. Tracking is quite difficult in itself, especially when you are a multi state employer, and especially with those employees in employee friendly states like New York, California, Massachusetts, and Washington. There are also state and federal laws that require compliance, which make things even more difficult. So, some of the leave issues that you may come about when trying to manage these leaves and questions that you should be asking related to requests for leave are the following. Is the employee eligible for one or more leaves or benefits? If so, what is the timing behind certifying those leaves and getting employees paid? What is the difference between the leave versus the benefit? When and how do leaves and benefits run concurrently? When do they not? How do you coordinate payment with carriers or via payroll? How do you continue certain benefits if not being paid? When does use of paid time off come into play? And how do you track the leave to have documentation that you are compliant with state and federal laws? All of these questions should be asked every time there is someone requesting leave. So, how does an employer certify FMLA leave? Effective communication really is the key. Keeping lines of communication open, making employees aware of your policies, that will all make the process much easier. First and foremost, covered employers must have an FMLA poster. This is something that you're obligated to have where your regular employment posters are. It's called the general notice and it provides employees notice of their FMLA rights. So, all covered employees must provide notice of their need for leave. And really, under FMLA, that notice should be as far in advance as practicable. 30 days in advance is really considered reasonable under FMLA, but as you probably know, this doesn't happen all the time. However, the need is sometimes sudden, especially when you're dealing with an illness related to a family member, and often you're called upon last minute. So there is some flexibility within that notice requirement. Just be again open with your employees and explain that to them. Notice of the need may be oral or written. So an employee simply has to come and speak to someone about needing leave, whether it's their supervisor or human resources. That could be their request, or they could put it in a note, or they could send it in an email. Any of those qualify for a valid notice of a need for leave. They absolutely do not have to use the word FMLA. Some employers get confused and say, well, they didn't ask for FMLA, so I don't have to provide it for them. If an employee does state that they need a leave and you know that the reason for that leave is an eligible reason for FMLA, then that will be considered proper notice. The employer can ask the employee to schedule leave for planned medical procedures when it works best for the business. Not all employers know that. So if someone does request a need for leave and they don't have a something scheduled yet that relates to their own personal health, you can ask them to do that when it's best for the business. If notice of need for leave is given to a manager or supervisor, they may not know the rules behind FMLA or other leave. So they should be made aware, whether it be through training or otherwise, that they should contact HR or their leave administrator ASAP. And ASAP is a very important part of that because there are day requirements that the employer must respond to an employee's request, which we'll get into in a minute. So the timelines are very critical and must be kept. Employers must provide a rights and responsibilities notice to each eligible employee requesting leave within 5 days of that communication. So that's really why it's important that we educate anyone on the front lines who might be receiving this type of notice from your employees. This rights and responsibilities notice must include the period of leave, the reason for leave, whether further certification is needed, for example, having the doctor who's treating the employee providing some medical certification, and whether paid time off is required to be used and other conditions of leave, right to benefits continues, etc. In general, if an employee is eligible for FMLA leave, they are eligible for up to 12 weeks of FMLA leave during a single 12-month period. That time is increased to 26 weeks if an employee is in need of FMLA leave to care for a family member who is a covered service member with a serious illness or injury. Please note that when an employer has two spouses who both work for them, both employees are limited to a combined 12 weeks of FMLA leave if taking the leave for the same incident to care for a family member or following a birth, adoption, placement of a child. That same number is maxed at a combined 26 weeks for caring for a family service member when both of those employees work for the same employer. Intermittent leave is the most difficult type of FMLA leave to manage, and intermittent leave is when someone needs periodic leave that may not be every day related to a qualifying FMLA leave need. The Please note that as long as the leave is certified as FMLA qualified, you have to generally work with the employee when they ask for intermittent leave. Employees are entitled to take FMLA leave on an intermittent or reduced schedule basis when there is a medical need for this type of leave for an employee's own serious health condition. This often happens if they have more regular doctor's appointments that they must attend, and if they are doing regular therapies. Those are often not every day, but they might be on a more regular basis where intermittent leave would be useful. Intermittent or reduced schedule basis leave can be used to care for a spouse, parent, or child with a serious health condition, or to care for a covered service member with a serious illness or injury. An employee is also entitled to use intermittent or reduced schedule leave for qualifying exigencies. And an employee is not entitled to take intermittent leave for the birth or care of a newborn child or placement with the employee of a child or adoption for foster care unless the employer agrees to the arrangement. So, this is one area where the reason these employees are out is important, especially if they're requesting intermittent leave. The rules are different if they're asking for intermittent leave related to the birth or care of a child. However, and this is a big however, although employers are not required to allow intermittent leave for the birth or care of a newborn child or adoption or foster care, it is often a best practice to allow that so long as it does not provide an undue hardship to the business. It also may help support a paid family leave compliance when leaves run concurrently. So, depending on the state that your employee is in, and depending on the type of other leaves that may apply to the same type of leave, they often do allow intermittent leave for different reasons. So, it's really a balancing approach of trying to make it work for both the employee and the employer. One of the biggest protections that FMLA provides is reinstatement. It's really one of the biggest parts of FMLA leave policy. Following leave, employees must be restored to the same or equivalent position and be entitled to the same benefits and terms and conditions of employment as prior to the leave. unless they're among the highly compensated employees in the organization. So, what that means is you generally have to return them to their position that they held prior to going out on leave. A lot of people do ask, though, does this mean you cannot replace an employee while they're out? Well, the answer is yes and no. You can't permanently fill their position without having another similar position available for them upon their return. However, employers can temporarily hire or move someone to the position to assist while the employee's out. So employers don't have to shut down complete parts of their business just to accommodate an employee's need for leave. This is where documentation becomes very important. You want to make sure that you are documenting the situation to show that the person is not being hired or moved to permanently replace the employee going out on FMLA leave, were you to ever be audited. Another protection that FMLA provides, in addition to job protection, is benefit protection. As it relates to maintaining those benefits, FMLA requires that health insurance be continued under the same conditions as prior to the leave. Many employers also choose to keep all of their benefits for ease of benefits administration during an absence, although FMLA technically only requires that health insurance be continued. If applicable, arrangements must be made for employees to pay their share of health insurance premiums while on leave. FMLA allows for employers to ask employees to prepay for their benefits or to allow them to set up regular payments during their absence. Many times, those payment plans align with pay periods where their contributions would normally be deducted from a paycheck, or even pay a lump sum or have a payment plan upon return. It's really up to the employer as to what works best for their business. Please note that if an employee does not use paid time off to supplement their leave, payment for benefits will end up being made post tax, having them lose the benefit of the pre tax treatment of those benefits during their leave. Unfortunately, it's really difficult to have any other treatment. But really, FMLA offers flexibility to the employer as it relates to maintaining these benefits under the law. In some instances, an employer may recover premiums it paid to maintain health coverage when an employee failed to return back from FMLA leave. This language should be included in an employer's FMLA policy in the employee handbook. Some employees do fail to return to work following FMLA, which is often not the plan, and as such get the benefit of their health benefits during their leave only to return and not continue working. Often that means they're not paying back the balance that they owe. FMLA allows for employers to limit their losses a bit by requesting the full cost of maintaining those benefits if an employee leaves them high and dry following leave. So we're going to move on to state paid leave requirements. If anyone has any questions about FMLA or any other federal leave laws, we can answer those at the end or after the program. But please note for this presentation, New York paid leave is the focus. However, we do caution you that there are often issues when determining which states' leave laws apply to certain employees, especially if they travel for work, are remote, or work in multiple locations. Each state has their own state paid leave requirements, so it's important to be aware of those laws when you have employees in multiple states. So, New York State mandates that private employers provide paid family leave to eligible employees. Paid family leave is funded through employee paycheck deductions, or if for generous employers, can be paid fully by the employer. It's typically added as a rider to the employer's already existing disability insurance policy. New York State employers of out of state employers are also covered. So the key is, where is that employee working? If the employee is working in New York State law requires that they be covered by both disability and paid family leave. There's no paid waiting period once eligible. So, unlike FMLA leave, where they have to have worked for the employer for a year and for a certain number of hours, the requirement here is much smaller. So, both full time and part time employees are eligible. They both have a waiting period, both are about 6 months with a little bit different interaction of how they're working. So, full time employees who work regular full-time hours, which for purposes of this are only 20 hours, they'll be eligible after 26 weeks. This prevents them from taking any long-term leaves during those first 6 months of their employment. Similarly, paid part-time employees working less than 20 hours a week, they are eligible after 175 days. And those are 175 days of any work for the employer. So they don't have to occur necessarily within those 6 months, but typically it will be around the same timing for those employees if they are regular employees. Paid family leave benefits are taxable non-wage income that employees must include in their gross income for tax purposes. Please note, though, because it is a payment made from an insurance policy, taxes will not automatically be withheld from paid family leave benefits. So if you have employees going out on paid family leave, it's important that you let them know that they are responsible for paying the taxes on that benefit. There are waivers in a very rare circumstance for paid family leave. Those are really when you're hiring people for a very temporary work situation where upon hire that they will not get to that 6 month mark or that their project is very short term. In those cases, it's very difficult to judge that unless you have something identifying the term of the employment. If you don't have that documentation, I would recommend letting them know that they will be eligible for paid family leave and not having them sign a waiver. Please note that unlike New York State disability, which we'll talk about in a minute, New York State paid family leave has both an insurance benefit as well as a leave component. It also can run concurrently with FMLA. The eligible reasons for New York State paid family leave include when an employee needs to participate in providing care, including physical and psychological care to a family member with a serious health condition, when they bond with their new child during the first 12 months after the child's birth or after a placement of a child for adoption or foster care with the employee, for any qualifying exigency as interpreted under FMLA arising out of the fact that a spouse, domestic partner, child, or parent of the employee is on active duty in the military, or to help a family member prepare for or recover from surgery related to organ or tissue donation. Please note that the definition of family under New York State paid family leave law is very broad. It's much more broad than FMLA. It includes siblings, children, parents, grandparents, step and in-law parents and grandparents, and siblings, as well as those whom you provide care for like a parent. This is one area that may potentially make an employee eligible for paid family leave, but not for FMLA. Use of paid family leave for military reasons includes helping to care for loved ones whose family member is deployed abroad or in active military service. So, for example, if a parent is deployed, a grandparent can take time off under New York State paid family leave to care for their grandchildren while their parent is deployed. On this slide, this identifies the benefits associated with New York State paid family leave. It shows both the leave portion as well as the benefit. Please note that this is updated annually and will change, so you have to keep an eye on this. As you can see, the amount of leave is 12 weeks of leave, which is similar to FMLA. The benefit associated with this is a 67% benefit paid. That is capped out. There is an average weekly wage that New York State imposes where they maximize the benefit that an employee can make. So it's 67% of the maximum amount that New York has named for the year. And you can ask employees to contribute to their insurance benefit. It shows on this chart the percentage that they can contribute to the plan and the maximum amount that you can take from their paycheck annually to cover these premiums. New York State disability insurance, like I said, is often part of the same insurance plan that New York State paid family leave is. The paid family leave is usually a rider to the disability insurance plan. New York State requires employers to provide disability benefits coverage to employees for off-the-job injury or illness. Coverage for disability benefits can be obtained through a disability benefits insurance carrier. The disability benefits law provides weekly cash-only benefits to replace, in part, wages lost due to injuries or illnesses that do not arise out of the course of employment. Payments will be made for a maximum of 26 weeks in a 52-week period, and medical care is the employee's responsibility. This benefit does not provide any coverage for medical. Please note that although New York requires employers to provide disability insurance, it is only that. It's an insurance benefit and does not provide a separate leave component. As a result, an employee is not otherwise required to be paid, nor are they required to be provided with leave unless it qualifies for FMLA or another employer policy or type of leave. New York State disability benefits will pay 50% of their average weekly wages, calculated over the average of wages received in the 8 weeks prior to the leave, up to a maximum of $170 per week. And that amount is subject to Social Security and medical taxes. So you can see a pretty significant difference for needing to be out for your own disability, for an employee's own disability, versus them being out to care for a family member. We're keeping an eye on this to see if New York increases the disability amount, because that $170 a week is very, very low. Benefits will begin on the 8th consecutive day out of work, because the first 7 days are considered an unpaid waiting period. There's no waiting period, however, if you've been collecting unemployment for more than 4 weeks. An employer is allowed but not required to collect contributions from its employees to offset the costs of providing disability and paid family leave benefits. On the previous slide, we discussed the amount that they could take out of an employee's check for the paid family leave portion. But they are maximized at an amount of 60 cents per week to help cover this disability insurance. And one side note, an employee can never collect disability and paid family leave benefits at the same time. So more about New York State disability insurance. All workers who are considered employees working in New York must be provided with New York State disability insurance, with a few exceptions. You'll note there that clergy, teachers in a nonprofit, and those receiving charitable aid are amongst the very few exceptions to this rule. As we noted on the earlier slide, there is a 7-day waiting period for benefits, and benefits don't begin until the 8th day. However, this is one of those important moments for an employer to start looking at why an employee is out. So if an employee calls into work for a day, a couple days, maybe 3 days, they may be out for a regular illness, or maybe it's a minor injury. But when that leave needs to be extended, then you should start counting the days and thinking about whether you need to start talking about making a claim for disability. It's important that the employer track those days, especially as it relates to the 7-day waiting period that disability requires. Please note that even if an employee is unemployed, a newly unemployed employee, or even out longer, they are still eligible for disability insurance benefits. Depending on how long they've been unemployed, the state will pay for those benefits, or the previous employer will be liable. Now we're going to move on to workers' compensation insurance. So, in complete opposition to disability insurance, where the disability plan covers an employee's illness or injury that occurs outside of work, workers' compensation insurance is a similar insurance plan that covers employees who have an illness or an injury that occurs while they are working. And New York state law requires employers with at least one employee, even one part time employee, to have continuous workers' compensation insurance. This requirement also includes family members that may be employed in the business. Please note that although New York requires employers to provide workers' compensation insurance, it is only that. Again, like disability, it's an insurance benefit and it does not provide a separate leave component. As a result, an employee is not otherwise required to be paid, nor are they required to be provided with leave unless it qualifies for FMLA or another employer policy or type of leave. Workers' compensation in New York is a system that provides medical care, weekly benefits, and vocational rehabilitation for workers who are injured or ill due to their work. The benefits are calculated based on the worker's average weekly wage, degree of disability, and duration of disability. Workers who are eligible for workers' compensation can file a claim with the New York State Workers' Compensation Board. So here's a relatively new additional type of paid leave that New York now requires employers to provide. New York State enacted statewide paid sick leave in 2020, and employees were able to start using New York State paid sick leave as of January 1st in 2021. This New York State sick leave law requires employers to provide their employees with leave for reasons relating to health and safety of the employee or the employee's family. How much leave is required and whether leave must be paid depends on the employer size. Employees accrue 1 hour of sick leave typically for every 30 hours work, or at least that's the minimum that they must accrue under the law. Employers may front load the total amount of sick leave to employees at the beginning of the year instead of accruing that amount if they prefer, based on their own internal policies. And employees may carry over unused sick leave to the following calendar year. In fact, the law requires that employers allow them to do so. So, why can you take New York State paid sick leave? Employees may take paid sick leave for the following reasons: an employee's or an employee's family member's mental or physical illness, injury, or health condition, for the diagnosis, care, or treatment of mental or physical illness, injury, or health condition of, or need for medical diagnosis of, preventative care for an employee or an employee's family member, or an employee or employee's family member has been the victim of domestic violence as defined by state law, a family offense, sexual offense, stalking, or human trafficking. On the next slide, you'll see the chart that identifies the amount of leave that each employer, based on their size, must provide. As we said earlier, New York State paid sick leave is based on employer size and in some cases the revenues of that employer. If there are fewer than 5 employees, then you need to look at revenues. If annual net income is less than 1 million, then the employer must provide 40 hours of paid sick time. However, it does not need to be paid. However, if the net income is 1 million or more, those 40 hours need to be paid. Employers with fewer than 100 employees provide up to 40 hours of paid sick leave. And employers with 100 or more employees must provide up to 56 hours of paid sick leave. So obviously this, since 2000, has provided an additional 2020 has provided an additional burden that employers must provide paid leave for their employees. And to add to that burden, we have a new paid leave that New York has just started. As of January 1st, 2025, New York State has become the first state in the country to allow paid leave for prenatal or pregnancy related care. All employees of private employers in New York State are eligible for up to an additional 20 hours of paid time off in a 52-week period for prenatal care. This is in addition to all other paid time off offered by law or by policy. No minimum number of employee requirement is required under this law, and there's no time of service required to be eligible. An employee literally is eligible the day they start working for an employer. It covers healthcare services related to pregnancy, including physical examinations, medical procedures, monitoring and testing, and discussions with a healthcare provider related to pregnancy. This includes in vitro counseling and end of pregnancy appointments. Please note, and I know this question has come up and it was actually submitted prior to today's presentation, that employers are prohibited from asking employees for proof of treatment or for asking them to reveal confidential medical details. Employers also may not require employees to use another bucket of time off before using prenatal leave. In addition to New York paid sick leave and the new prenatal leave law, we are still burdened by paid leave for COVID-19. I think most people in the state realized that it would be sunsetting soon. I think most HR professionals thought it would be sunsetting in 2024. However, it was expanded to provide leave until July of 2025. So we do need to keep our eye on that, but we are still required as employers to provide job protected leave if an employer or his or her family member contracts COVID-19. It's meant to be a combination of benefits, including employer provided paid sick leave, paid family leave, and New York State disability benefits based on whoever has contracted COVID-19. Paid leave and the amount of leave benefit depend on the employer's size and revenues. And New York is one of the only states that has continued this type of benefit. Please note, as I mentioned, this leave is set to expire on July 31st, 2025. Um, we're hoping. um, the benefit can be used up to 3 times, once for a family member's positive test or symptoms and twice for your own positive test. The best practice is to have an employee do a self attestation as well as show a copy of an at home COVID test, since there is no longer a PCR test requirement or a certification by the city or county as we experienced early in the pandemic. Please note that these paid days off are for each incident of COVID. That is, for example, if you are eligible for 5 COVID sick days under the chart on the slide, under this legislation, you are entitled to 3 sets of 5 days off for 3 separate incidents of COVID. This is in addition to other sick leave provided to the employee. So, one of the biggest parts and confusion about dealing with leave administration is really trying to figure out what type of leave the need for leave qualifies for, if it qualifies for more types of leave than one, and then if it's for multiple types of leave, how do you track that? This is really where the rubber meets the road and things really start to get difficult. And having to track these leaves and benefits when eligible can often become quite administratively burdensome. So let's see some of the interactions of various paid leaves that we've just discussed. So if an employee has an event that qualifies for leave under New York State Paid Family Leave and FMLA, an employer may require the employee to take the leaves concurrently. That means that you can give them 12 weeks only versus the 12 weeks that each separate leave type would allow for them to take. If an employee uses FMLA for an event that doesn't qualify for New York State paid family leave, then the employee will still have New York State paid family leave available. It is possible that an employee may not be eligible for FMLA even if it's eligible for paid family leave due to the difference in time required for eligibility, or if it's to care for a family member, the definition of family member under that type of leave. Employees can't collect short-term disability and New York State paid family leave benefits at the same time. That's a question that comes up quite often. So please remember that disability is for an individual's own health condition, whereas New York State paid family leave benefits are used for caring for a family member. Employees cannot collect New York State paid family leave benefits similarly while they're collecting workers' compensation or for total disability. In addition to the paid leaves and benefits described today, there are many additional mandated leaves in New York State. Lactation leave, which started in June of 2024, has gotten a lot of press. Lactation leave and benefit has always been required by New York State, at least going back for the last 10, 20 years. But previously, it was not mandated to be paid. Now, since June 19th, 2024, employers must require employees to take leave for lactation reasons and also be paid for that time. And there should be a policy in your employee handbook discussing that new type of leave. Victim and witness leave, emergency responder leave, military leave, blood donation leave, bone marrow donor leave, voting leave, jury duty leave, and military spouse leave are all other leaves that New York State requires. Many of them require their own posting. So when it's time for voting, there you have to have a notice up that shows employees that they're allowed to take time off to vote if they don't otherwise have time outside of the workday. At this point, I'm going to turn it over to Raleigh for a brief word about our leave management service, and then I'll be back to answer some questions. Raleigh?
All right, Jen, great job. Okay, so here's what we'll do. Let me tell you about this. We have Jen available for answering questions for you beyond what we get to today. So if we don't get to your question, you can reach out to Jen. And one of the last slides coming up will have her contact information. Also, if you have um, want more information just about the services offered by GTM for HR consulting and audit services and the like, you can talk with Kalina Castiglione, and her contact information will show up in a slide in just a few minutes. What we're going to do now, if this is good by you, Jen, we're going to go to some of your questions. We had some that came through in the sign up process, so we'll get to them first. And again, if we don't get to your question right now, we will be back in touch with you within the day by tomorrow and answer that question for you, help you out. So if you're ready, Jen, here's question number one. Do employees need to have the 5 days of New York State paid sick leave available to them as of January 1st, or can it be done on an accrual basis? How does it all kick off at the
So
beginning of
the
the
law
year?
the law allows some flexibility for the employer. It gives them the option of allowing employees to accrue that time or making it available on January 1st. So really that's up to the employer whether they want to require that to be accrued, which is 1 hour for every 30 hours worked, or if they want to make it available on January 1st. I do have to say, as a side note, the New York state law does require that an employer allow employees to roll over any accrued but unused paid sick leave that up to the maximum amount that they can use based on the employer side. So after the first year of their employment, they're going to have generally have time available for them on January 1st to take, even if it is not the employer's decision to do so. So if they had a good year and didn't have to take a lot of sick time and have 30 or 40 hours of paid sick leave available at the end of the year, that will roll over and be available on January 1st, even if the employer has a rule about having to accrue the additional time for the following year.
Is the employer or the employee the one required to track that rollover time, whatever may be left over from the previous year going into the new year?
No, so the employer should be tracking the use of that paid sick leave, whether it be through their time management system or whatever way they usually track use of leave and use of time off. It
Mhm.
typically is accounted for on the pay stub, and you can see a line item on that. It doesn't always note the number of hours or the number of days. So typically they will have a human capital management system that they're using that has on the profile page for each employee how many paid sick days they have left. But ultimately, it is up to the employer. It's the employer's responsibility to track that amount and to make sure that the employee is aware of any rollover amounts that are going into the next calendar year.
Okay, thanks. Are we obligated to ask if the employee wants to use New York State paid sick leave when they call in sick?
So you're not obligated to ask if they are calling in and telling you that they will be out for a reason that is eligible for New York State paid sick leave, then it should be accounted for as New York State paid sick leave. If they are calling in for another reason and you do not have a policy that allows them to use paid sick leave for other reasons, then it would not be denoted as paid sick leave. But you do not have to ask the employee what type of leave they would like to use when they're calling in. You should just be saying they are using that. I typically go right to sick leave if it's a qualifying reason because I'd rather have them use that state required leave than some of the other personal or vacation time they may be accruing and maybe more important to say for, an important family trip or something like that.
If you have an employee that works remotely or out of state, does that employee, when they apply for leave, does the employer calculate that based on where the employee is working from or from the employer state? How does that
So,
sort of that?
yeah, it's a little bit tricky, but New York State, all of their leave laws are looking at where the employee is working. So, even if the employer is an out of state employer, let's say they're located in Massachusetts, but they have employees working in New York State, they are required to provide the various types of leave and sick time for employees who are working in the state of New York. I would say that the majority of states have that same type of rule where they're looking really at where the employee is working. This becomes a little bit difficult when people are traveling for work or they're working remotely. In those cases, you would really want to look at how often they're working in the state. But in employee friendly states, which New York happens to be one of the most employee friendly, um, You always should err on the side of providing that leave to them when that employee is doing work in the state.
Excellent. Well, that's all the time we have for the questions today. So, Jen, thank you very much for sharing your expertise with us. There's that slide as promised with both Jennifer and Kalina's contact information for more information and answers to your questions. We thank you for joining us today. Be sure to look for that email a little later today. It will have the link to a video of this presentation and also have a PDF version of today's presentation. Thank you all very much. Have a great rest of your day.
Thank you.